Saturday, June 21st. About to smoke up some purple punch, sir. Yeah, we about to blaze in this bitch. Yeah, we popping. Like Chili say, ain't no stopping. Yeah, we going. Yeah, we moving. Yeah, we grooving in this thing. Got to get paid. Section 1883. Yeah, I'm getting it. And my friends. Yeah, we moving in this thing, huh? Well, I can't say grand rising, but I can say it's a beautiful day. I can say that much. I hope all of y'all are doing so good. I hope all of y'all are so blessed. I'm so thankful to be here with you all. I'll tell you that much right now for real. And yeah, today we're gonna try and get through this court of hell in the state of Inferno. Last time we wasn't able to. But y'all go ahead and hit that like button. Let's get some more people off in here. I know it's Saturday night, so a lot of people are gonna be out doing their thing, chilling with family. Went out for a ride, got to chill with the fam. We did Operation Wise Dome this morning. It was lit. If y'all missing on that, hey man, all you got to do is go to piitp.com and get up or become a member for Operation Wise Dome. But what I want to do is I want to get into this court of hell. Okay, the court of hell. Yes, that's what I want to get into. Let's see, window, or do we just show the entire screen? Let's just do entire screen. And we're finally going to get this done this time, hopefully. Last time we had baby girl interrupt, but you know, baby girl comes first. But this is going to be the Court of Hell, State of Inferno. State of Inferno versus Cameron James Wilson. Case number is 369-124245. You know, my numerology, it comes out right. And then the official court transcript, the judicial or jurisdictional challenge hearing. And this is if you're wanting to challenge jurisdiction. If you're wanting to challenge jurisdiction and go all the way with it, bar none, no F's given, well, here it goes. I hope y'all are ready. What's up, Jonathan Nelson? I hope everybody is good. Y'all let me know what y'all, who's all in this thing. Y'all say something in the chat so I can shout you out. You dig? All right, let's get it. Mr. Wilson, you are here today to answer the charges brought against you. How do you plead, guilty or not guilty? Your Honor. Oh, wait, I ain't even. Oh, okay, yeah. Turn this down, so I'm sorry. Your Honor, before I can enter a plea, I am here by special appearance solely to challenge the jurisdiction of this court. I require the prosecution to prove on the record that this court has both subject matter and personal jurisdiction over me and this matter. Now, something real quick I just want to mention is that a lot of the times when we come in here and we start showing that we know what we're talking about, we got people that love to go and make multiple videos. They find our court hearings and they make videos about the case not being dropped immediately on an arraignment. What kind of sense does that make? It doesn't happen all the time, but it does happen. It's happened with me several times, okay? They will never showcase that. They will only showcase people getting ran over. But I always think it's funny that coming in the most advanced legalese manner, knowing what we know, which has nothing to do with a sovereign citizen. The sovereign citizen, we know the definition of that, but let's just say we're going into the aspect of a sovereign citizen movement. And what is that sovereign citizen movement? Well, that's a propaganda machine. It's a propaganda machine to keep you away from the term sovereign citizen. And then, of course, there's a whole bunch of propaganda to keep you away from what sovereign or what they label sovereign citizens. So that way, ignorant people are out here now that anytime you come forth in an advanced, highly intellectual manner of legalese, speaking even higher and more efficiently than a lawyer would, because, you know, the lawyer's just going to tote the line, we get called sovereign citizens. Now, I don't mind being called a sovereign citizen, but I digress at this time, okay? I've explained that plenty enough to y'all. So the court, this is a criminal court, and this court has jurisdiction over such matters. You need to enter a plea. Yeah, I bet you want me to. I don't need to. You need me to. So, Your Honor, I do not waive any rights, and I do not concede jurisdiction. I respectfully request that the prosecution prove on the record every element of jurisdiction, including subject matter and personal and territorial jurisdiction. Until that is done, I cannot enter a plea. The court assumes jurisdiction because this case falls within its legal authority. Now, how do you plead? I object, Your Honor. I do not accept the court's assumption of jurisdiction. Assumptions are not proof. I challenge and rebut any and every presumption of jurisdiction. I require the prosecution to provide evidence of proper jurisdiction on the record. Until they do so, this court has no authority to proceed. The court. The charges are filed in this court and gives us jurisdiction over you. Enter a plea. Your Honor, I respectfully object. Filing charges alone does not grant jurisdiction. I'm not submitting to the court's authority until and even if the prosecution proves evidence that this court has subject matter jurisdiction, personal jurisdiction over me, and territorial jurisdiction, all of which must be proven on the record. I demand proof, not presumption. Now, Mr. Wilson, you cannot delay these proceedings. This court has jurisdiction and you must enter a plea. Your Honor, again, I am not attempting to delay, and I object. I am simply invoking my right to challenge the court's jurisdiction, which is the fundamental element that must be proven before any proceedings continue. The burden of proof is on the prosecution, them, the state. And until they satisfy that burden, I cannot proceed. The court. Turning to the prosecutor, does the prosecution have any evidence to present on jurisdiction? Your Honor, the charges have been filed in this court, which has the authority to hear criminal matters. The defendant resides in this jurisdiction, and the alleged crime occurred here. I object. Your Honor, the prosecutor's statements are not evidence. I demand specific factual evidence be placed on the record and on the record to prove jurisdiction. The court must establish through admissible evidence that it has jurisdiction over both the subject matter and my person. The prosecutor has presented none. The court. Mr. Wilson, these are standard proceedings now, and the court has jurisdiction based on the charges and the location of the crime. Your Honor, I again respectfully object. The legal standards cannot replace factual evidence. Factual evidence, not hearsay that has been brought forth in relation to an information sheet and or incident report by a police officer. I challenge the court to provide factual evidence of jurisdiction as assumptions and standard practices do not fulfill the legal requirement of proof. Until jurisdiction is established on the record, I do not submit to the court's authority, nor will I enter a plea. What's up, Danny? What's up, Jonathan Masley? What's up, Thomas Foolery? The court. Mr. Wilson, you are required to follow the procedures of this court. Your Honor, I understand, or should I say I comprehend because I stand under nothing. However, I am exercising my right to challenge jurisdiction, and I request that this court acknowledge that no plea can be entered until jurisdiction is proven. I reserve all rights and rebut all presumptions that this court has jurisdiction unless it is established on the record. Get it on the record. For real. Prosecutor, Your Honor, we believe the defendant is attempting to delay the case. I object, Your Honor. I'm not attempting again to delay anything. I am exercising my right to ensure that the court is operating within its lawful authority. Jurisdiction must be proven, not presumed. And I am merely requiring that the prosecution to do their duty, and establish it with admissible evidence. All right, you've made your point, Mr. Wilson. However, the court will move forward, and I will ask you once more, how do you plead? Your Honor, with all due respect, I cannot and will not enter a plea until the prosecution has proven jurisdiction on the record. I maintain my challenge and my objection to the court's authority to proceed until this matter is settled. Mr. Wilson, this court has already stated that we have jurisdiction based on the location and the alleged crime and the charges. You are delaying the proceedings by refusing to enter a plea, and I must warn you that if you continue, there could and might be consequences for obstruction. Your Honor, with all due respect, what's up, Slasha? I am not obstructing these proceedings. I am asserting my legal right to challenge the court's jurisdiction, which has not been proven on the record. As you are aware, once jurisdiction is challenged, it must be established under law, not proper presumption or assumption. So if we need to go ahead and bring forth a jurisdictional hearing, let's go ahead and schedule that rather than arguing. The court. The prosecution has already stated that the crime took place within this jurisdiction and you reside here. What more do you require? Your Honor, I respectfully submit that statements from the prosecution are not evidence. In a matter this serious, the court cannot proceed without proof of jurisdiction that complies with the law. The court cannot assume jurisdiction based on mere assertions or location. It must be proven. I demand that the prosecution provide or produce lawful evidence demonstrating this court's authority to hear the case. This court handles criminal matters like this every day. We have jurisdiction and the charges have been properly filed. I'm asking you for the last time, Mr. Wilson, how do you plead? Your Honor, I can do nothing but again respectfully object. It is established law that jurisdiction must be proven once challenged. I have raised a challenge, and the prosecution must meet the burden of proving with evidence that the court has subject matter jurisdiction, personal jurisdiction, and territorial jurisdiction. Until they provide this proof, any actions this court takes would be void ab initio and without legal effect. Your Honor, we have already indicated that the crime occurred within the state and that the defendant lives in this jurisdiction. That should be sufficient. I object. This Peabody over here, this is not sufficient under the law. State, I require the prosecution to prove these elements through proper documentation, real, true, proper documentation, or admissible evidence on the record. Merely stating that a crime allegedly occurred here is not enough. That charging document, that information sheet that they have is not supported with a corpus delicti or injured party with a sworn affidavit. Now, the law requires proof of jurisdiction, and I challenge the prosecution to present it. The court has jurisdiction. We are just moving forward. Your Honor, I must object again. If the prosecution cannot produce evidence on the record that establishes jurisdiction, I move for dismissal of this case for lack of jurisdiction. Under Constitution and common law principles, jurisdiction must be proven, not presumed. And any further actions taken by this court without proper jurisdiction will be ultra-vires beyond the court's legal authority. This is not a time for legal lessons. You are expected to participate in these proceedings like everyone else. The court has jurisdiction and we will proceed. Your Honor, I do not seek to lecture, but I must insist on the rule of law. The prosecution must meet its burden. I cite the case of Ex parte Young and others, which demonstrate that jurisdiction must be established once challenged. This is not a trivial matter. I respectfully demand that the prosecution produce evidence, whether in the form of affidavits, certified records, or other lawful documentation that proves jurisdiction. Until this is done, I cannot proceed in any other manner. Turning to the prosecution, does this prosecution have anything further to add on jurisdiction? We have already explained that the crime occurred within this court's jurisdiction, and we have presented these charges. I object again, Your Honor. The prosecution has only made assertions which are not evidence. I require the production of specific evidence on the record to prove jurisdiction. The law requires proof, not allegations. I demand to see documentation such as the lawful authority under which this court is proceeding, proof of proper service, and any other necessary evidence to establish the court's jurisdiction. Frustrated. Mr. Wilson, the court has already stated that we have jurisdiction, and I will not entertain this further. Your Honor, I respectfully, I must continue to challenge the jurisdiction until it is proven according to law. By refusing to provide proof of jurisdiction, this court is acting beyond its lawful authority. I move for dismissal based on lack of jurisdiction. If jurisdiction cannot be proven, then this court has no lawful standing to proceed. We are not dismissing this case. This court has jurisdiction, and we are proceeding with or without your cooperation. Your Honor, I maintain my challenge to jurisdiction and continue to rebut any and all presumptions. Jurisdiction has not been proven on the record, and any actions taken without such proof are null and void. And I will not concede to jurisdiction until the prosecution has fulfilled its legal obligation to provide evidence of the court's authority over both me and this matter, which it will never be able to do. Mr. Wilson, the court has already stated that it has jurisdiction over this matter, and we are moving forward. And I will ask you again, how do you plead? Your Honor, I must object again. It is well established in law that once jurisdiction is challenged, the burden lies with the prosecution to prove each and every element of jurisdiction. This includes subject matter, personal jurisdiction, and territorial, until the prosecution submits actual admissible evidence to substantiate any claims of jurisdiction. The court cannot even lawfully proceed. So I definitely do not consent to the court's jurisdiction, and I require that it be proven on the record. The court has jurisdiction over the crime alleged and to have been committed in this jurisdiction. Your repeated objections are delaying the prosecutions, Mr. Wilson, or proceedings. Your Honor, I respectfully, delays are irrelevant where the court's jurisdiction is in question. Without jurisdiction, this court has no authority to take any actions, and any rulings or judgments would be null and void from the start. Presumptions are not evidence. The prosecution must provide actual admissible evidence to provide jurisdiction, and until that happens, the court is proceeding unlawfully. Your Honor, the crime occurred within the state. The defendant lives here, and the charges were filed properly with this court. We assert that jurisdiction is clear. What I'm trying to get you to understand, okay, no, and I'll keep going because it has to hit home. You really have to get it. And that's why this is so repetitive. The court, Mr. Wilson, this court is authorized to hear criminal matters in this jurisdiction, and I see no reason to delay further. Your Honor, with respect, I must point out that the court cannot proceed unless the prosecution proves every element of jurisdiction under law. The prosecution has failed to provide any actual evidence. Until they can produce evidence of, number one, the subject matter jurisdiction, the court's authority to hear the type of case at hand, two, the personal jurisdiction that the court has authority over me as the accused, and three, the territorial jurisdiction that the alleged crime occurred within this court's lawful authority, this court cannot proceed. Any presumption or assumption without evidence is a violation of due process. Presumption of jurisdiction is not enough under the law. Jurisdiction must be proven on the record when it is challenged. I challenge and rebut any presumption of jurisdiction, and I demand actual evidence. What you got to understand is this is a real, true thing. This is repetitive for a reason. The prosecution is repeating assertions without providing actual proof. I have to keep repeating myself over and over because it's like y'all will not stop in trying to bring me into jurisdiction or have me acquiesce. I will rebut every single time. The location of my residence does not alone establish personal jurisdiction in a criminal matter. Me living wherever I live does not give you power over me. The law requires the prosecution to prove with evidence that all elements of jurisdiction are satisfied, not just through stating it on a piece of paper or verbally. I request a certified, verifiable proof that, one, the court has legal authority to hear criminal matters of this type. Two, yeah, they tried to get me. Look how they did me, man. But it's all good. We back. We all good. We ain't getting defeated like that. No, sir. Gonna do me dirty like that. We back, baby. Let's go. Nah, they ain't gonna get me like that. They ain't stopping me. I know they're gonna try, but I'm gonna make it work. So yeah, I'm with it. You dig what I'm talking about? So again, what I was saying is just running through the rest of this bad boy, we have to understand is you have to rebut every single presumption that is brought forth. Okay? Do not let them get any aspect, an inch at all. They're going to continuously try over and over. And then they'll try to go to a different subject on your ass. Don't even let them try that. You got to stay on top of it. Rebut every presumption. Now, the key legal principles that were demonstrated throughout this proceeding and throughout all of this situation is special appearance. We're about to go through that as well. I'm about to show y'all just some documents, affidavits, things that we file into the court as far as how we're making our appearance, at least us within Wise Dome, pro se, sui juris, pro proper personas. And they accuse, what we do is we make a special appearance. You're a defendant in error. You're innocent until proven guilty, right? So if you're innocent until proven guilty and there's any bias that's shown against you by your right, utilizing your right to be heard, like they did with my girl Sydney, is the aspect that right on the record, first appearance, please let it be known that the defendant is a sovereign citizen. Did I call myself that? Did I label myself that? I'm sure I label myself as a living woman. For you to then label me as a sovereign citizen on the record in open court is totally biased and prejudiced. I cannot. There's no eligibility for me to be able to get a fair trial whatsoever when you're throwing these proceedings up into the public out on YouTube freely, Butler judges. How you think I'm going to get a fair trial if anybody within this county saw it? And how are we going to know if they saw it or didn't see it? And you just clearly out here throwing your bias and prejudice against me by calling me a sovereign citizen. I don't have a problem with it. I would enter something into the record that would rebut all presumptions. But I would have went off. I mean, it would have been, I would have sued him. The accused rebutted, now challenge to presumptions, the accused rebutted every presumption of jurisdiction, emphasizing that the court cannot assume jurisdiction, that all jurisdictional elements must be proven on the record. Demand for the accused demanded that the prosecution provide actual admissible evidence to prove jurisdiction, not mere assertions or presumptions. This included subject matter, personal, and territorial. Refusal to plead without proof. The accused refused to enter a plea until jurisdiction was proven, stating that any plea or participation in proceedings would concede jurisdiction. Now, let me let you know something. I'm sorry y'all ain't seen the screen. I'll get it back on here. But when I was working just with my boy Quentin last night, and he was looking into rules procedure, once jurisdiction is challenged, they cannot even put a plea into the record on your behalf. In fact, they must call forth a jurisdictional hearing. That's how it goes. They can't enter a plea on your behalf. Period. Subject matter. The accused demanded evidence that the court had the authority to hear the specific type of case, criminal in this scenario, and that the crime charged fell within the court's scope of authority. Personal jurisdiction challenge, territorial jurisdictional challenge, objections to all assumptions, burden of proof to the prosecution, a request for certified documentation, contempt avoidance. The accused always remains respectful and avoids being held in contempt by clearly stating that they were exercising. If you're staying in honor, if you're staying in respectful, you shouldn't have them threatening contempt. Respectfully, Your Honor, I may disagree. Your Honor, I do disagree. Your Honor, I object. Respectfully, I must state. Respectfully, again, Your Honor, these aspects, I'm not being disrespectful, bro, but you're not going to run over me. You dig what I'm saying? Due process violations, constant objections, citing legal authority, jurisdictional rebuttal throughout, prosecution's failure to provide proof, objection to delays, motion for dismissal, judge's reluctant compliance. What is this one? Okay, and then that's the end of that one. So now what I want to go into is I want to look into my boy John Brown. He's over there in Kansas. And this is something very similar to Sydney. Kansas has very good law, at least case law, for this actual topic. This is what's called an affidavit, okay? And this is an affidavit of fact and verified claim in support of dismissal for equity and relief. And this is made specifically for Kansas and John, okay? And so this is kind of the stuff that we do on the back end in Operation Wisdom. Really, this is actually what we do through consultations. But this, he has some tickets coming out of the municipal court of Hayesville in the state of Kansas. And it's in the matter of an improper traffic enforcement, right? And it's an affidavit, in fact, of verified claim in support of dismissal and equity relief. Now, again, what you'll notice is this special appearance and jurisdictional challenge right off the bat. What it says is notice of special appearance and jurisdictional challenge. This affidavit constitutes a special appearance, not general, for the limited purpose of challenging jurisdiction in personam, in rem, and in subject matter, and establishing the record of constitutional rights violations pursuant to the principles articulated in Ex parte Young 209 U.S. 123 1908 and Hale versus Hinkle 201 U.S. 4374 1976. All rights are reserved, no nunc pro tunc, now for then, and this affidavit is submitted with explicit reservation of all rights pursuant to Kansas statutes subsection 84-1-308, which is also UCC-1308. Okay. Yes, Kansas statutes does have codified UCC. It's subsection 84-1-308. It's almost the same. There's just an 84 before. Now, in the doctrine of sine qua non, without which not. First section, affirmation of capacity and standing. I, John Brown, a natural man and living soul, being of sound mind and competent to testify, having firsthand knowledge of the facts herein, and being over the age of majority, do hereby solemnly affirm, declare, and state the following pursuant to the penalties of perjury under the laws of the United States of America and the state of Kansas. 1. That I am of lawful age and competent to testify to the facts set forth herein, pursuant to the standards established in Kansas statute subsection 60-407, general rule of competency. that I am not a legal person, a corporate fiction, an artificial entity, a surety, or statutory creation, but a living man, one of the people, possessing inherent, unalienable, down by the Creator, as recognized in the Declaration of Independence and affirmed by principles articulated in Hale versus Hinkle, where the court distinguished between natural persons and corporations, noting that the individual may stand upon his constitutional rights as a citizen. Now, my bad. I'm not even showing the screen again. Damn, I keep doing this. Y'all ain't even seeing none of this, bro. Let me show y'all. Let me come back up. So again, this is in the Municipal Court of Hayesville in the state of Kansas in the matter of the improper traffic enforcement. This is an affidavit of fact and verified claim in support of dismissal and equity relief. All right. Affidavit of fact and verified claim in support of dismissal and equity relief pursuant to 28 U.S.C. subsection 1746 and Kansas statute subsection 53-601. Thank you for your service and thank you for appreciation, Lord Primate. Thank you for being thankful. And so this is what I was talking about as far as the intro and the document on pretty much all of my documents, and I think pretty much all of us as far as pro se, pro persona, and sui juris, as we're bringing this forth as far as our notice of special appearance and jurisdictional challenge. And then we come through with an affirmation of capacity and standing. Now, this is one of the initial documents that we bring forth, the affidavit with a declaration. And the reason that we're doing it like that is because the declaration, the affidavit is supporting the facts of the matter because you're bringing your facts forth. The declaration is a notice and demand type style to demand them on to go ahead and dismiss this based on the constitutional violations that have been brought forth on the front end, right? And if you have a whole bunch of, if you got a whole bunch of constitutional violations, they're way up here. Constitution's way up here. And then you got creator endowed rights that are way up here. So they're even higher. These are your rights that are a part of nature that can never be overtaken, right? So like we know that nature has a right to move. It has the right to movement, right? Like nobody's going into Africa and stopping the elephants from walking. Why? Because they have a right to move. It's part of nature. It's a part of law, right? Nobody's just going to block them like that. We're part of nature. So I'm not comprehending the aspect on why I'm being controlled as though I am not part of nature and that I don't have the freedom of movement by any means that I see fit. It's like back in the day, we even knew like anybody could get up and create those air balloons and take people on air balloons. And I mean, it was just, come on, man, you can't be controlled in certain matters, right? Okay, so what I wanted to bring forth now is entire screen. Yeah, we've developed over 937 projects, just so you know. Let me see what's going down. So we've got, I wanted to take a look at Quentin's, and I think it was this one, if I'm not mistaken. Now, yeah, this is a notice and demand. Now, this is going to be a notice and demand to dismiss as unconstitutionally applied. Now, why is it a notice and demand to dismiss as unconstitutionally applied rather than just a motion to dismiss? Well, a motion to dismiss is you requesting the court to do something for you. A notice is of the highest authority. You're giving a notice stating that you must do something. It's a total different. There's two different frameworks as far as body of law is concerned in relationship to or in relation to the court. And the only reason that I can speak on this with confidence is because we got a verbatim announcement, or should I say, quote, from one of the judges in Luis's hearings, where the judge on the record stated to Louis that you've brought forth a motion, and we've taken this motion as an 8.3 CRR motion, and under the statutory framework and body of law. And he goes, if you would have filed it as a notice and demand to dismiss, as the statute is unconstitutionally applied with a memorandum and or points of authorities, then I would have to go into a whole different framework and body of law, a constitutional framework. That right there allows one to, whoa, you show up. Oh my goodness. Hold on. Hold on 1 second, y'all. Hold on 1 second. All right. So notice and demand to dismiss, right? Two different frameworks, two different bodies of law. That's how this works. Okay. Once you get into understanding those, you stop wanting to put motions in and you start wanting to enforce your power by notices because God, okay, man, government, everything is below you. Until you commit a crime, every single thing is below you. That's how this works. So, pursuant to KSA subsection 60 212B1, B6, and C, and the 4th, 5th, and 14th Amendments to the Constitution for the United States. Yes, this is Kansas. This is Kansas right here. We get that, cool. But try to really realize that it's pretty close to pretty much everything else that's out there. Okay, comprehend that. You can see that we really do good on development of our documents. This is a 23-page notice in demand, by the way. Nothing crazy. It's not, we're not throwing all these crazy theories out here and just, oh, it's nothing wild. I've always stated it it would probably be best to follow the yellow brick road. Because once you follow that yellow brick road, what you'll find at the end is a prize. It's that castle. And you're scared at first of that castle. You're scared of that Oz. You're scared of those robes. You're scared of the silk and satin. But once you realize that there's nothing more than a normal person behind that, and that you have all power and actually are above and are supposed to tell them where to move and what to do, that's where you win and get rid of the fear of Oz. So again, like always, the notice of special appearance and jurisdictional challenge, always, never waiving any rights. Comes now, Quentin, a sovereign individual and a living man, one of the people appearing in propria persona and sui juris, and respectfully moves this honorable court to dismiss with prejudice all charges and citations filed against him, and for declaratory relief. Pursuant to KSA subsection 60-212B1, failure to state a claim upon which relief can be granted. KSA subsection 60-212B6, failure to join a party under KSA subsection 60-219, and KSA subsection 60-212C for lack of subject matter jurisdiction, and the constitutional guarantees of the 4th, 5th, and 14th Amendments to the Constitution for the United States of America. This case presents a fundamental question of statutory interpretation and constitutional law that strikes at the very heart of individual liberty and limits of governmental power. Can law enforcement officers arrest individuals for traffic infractions when Kansas law explicitly prohibits such arrests? Oh my goodness. The answer, as demonstrated by clear and unambiguous language of KSA subsection 22-2401D, is an emphatic no. If you got any friends in Kansas, you better tell them to call your boy. People cannot be arrested for traffic infractions under Kansas law, period. Oh my Jesus. Let me read this to you one more time. People are going to be like, this soft sit idiot. Okay, I'm about to show you. It's so crazy that when you study and you are well informed, you're called an idiot. When you don't conform to false authority, you're called an idiot. They mock you, they ridicule, they laugh at you, and then they join you, right? It's all about presenting who you are. The Kansas legislature, in its wisdom and recognition of the fundamental creator-endowed right to travel, has established a bright line rule that protects citizens from the overreach of governmental authority and traffic enforcement. KSA subsection 22-2401D states with crystalline clarity, quote, any crime except a traffic infraction or a cigarette or tobacco infraction has been or is being committed by the person in the officer's view, unquote. This statutory language creates an absolute prohibition against warrantless arrests for traffic infractions, recognizing that such infractions are civil violations and not criminal offenses warranting the deprivation of liberty. Yes, in flagrant violation of this clearly established statutory prohibition, officers of the Butler County Sheriff's Office arrested defendant for alleged traffic infractions, thereby exceeding their lawful authority and violating defendant's creator-endowed rights to liberty, due process, and freedom from unreasonable seizure. This unlawful arrest was not merely a technical violation of procedure. It was a fundamental breach of the social contract between the people and their government, a violation of the sacred principle that government power is limited and must be exercised within the bounds of law. Are you starting to see? Are you starting to see? Now, I wonder if people come over here and they be like, oh, Cameron, but they're in court and doing this and doing that. They were never to be arrested. They were never supposed to be arrested, period. Ever. Ever. When we as the public are asking questions, you don't get like, you have 30 seconds to give me it now, or blah, 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 blah. Like, that's not how this works, bro. You're not going to demand. You're not going to tell me what to do. You're not going to act as though you have more authority over me. You're going to issue the tickets and treat me like the innocent person that I am. And until I get my day in court, that's when you can at least, give me respect. We all deserve respect. Now, what I'm trying to show you right here is that the officers of the law, this is a quote, by the way, in the execution of process, what process? What process? The process of law, are required to know the requirements of the law. And if they mistake them, whether through ignorance or design, and anyone is harmed by their error, through ignorance or design, meaning you didn't know or you did it on purpose, it doesn't matter. And if I'm harmed by your errors that you make, like Sydney was harmed, like Quentin was harmed, like all these people are getting harmed out here all across the United States, they must respond in damages. And that's coming out of Roger versus Marshall. I don't know what you want me to tell you. Public officials are not immune from suit when they transcend their lawful authority by invading constitutional rights. Well, if you're getting arrested out there in Kansas for any kind of traffic infraction, your constitutional rights have been you've been violated. Not only on Constitution, but then also on the statutory level. The statute straight says it. How many people right now do you know that live in Kansas that got a ticket and was arrested? I'm sure there are lots. Free money sitting in their lap. This unlawful arrest was, bounds of the law. So I guess I'll read statements of facts underlying. My homeboy was traveling. They got up behind him. He had a private plate on. Within 23 seconds, they told him to get out the car. He asked, hey, well, can I verbally ID? And dude was like, no. So dude didn't even have a chance to even verbally ID himself at all. So most significantly, the officers arrested him for a non-arrestable traffic infractions and direct violations of KSA subsection 22-2401D, charging him with interference with law enforcement, a Class A non-person misdemeanor, and failure to register a vehicle, an unclassified non-person misdemeanor. In a subsequent conversation between Mr. Hyde and Captain Andrews, we're not going to get into that. So the motion to dismiss standards. A motion to dismiss under KSA subsection 60-212B1 tests the legal sufficiency of the claims asserted. Brennan versus Giles, 281 Kansas, 2006. When the plaintiff fails to state a claim upon which relief can be granted, dismissal is appropriate. Here, the state cannot state a valid claim for traffic infractions that result in an arrest when such arrests are statutorily prohibited. A motion to dismiss under KSA subsection 60-212B6 challenges the failure to join an indispensable party. In this case, the absence of any verified complainant or injured party renders the prosecution fundamentally defective. And there is no party withstanding to seek relief for the alleged infractions. How am I supposed to, y'all saying, how am I supposed to give relief? Where's the verified complainant? Who's the injured party? The state. How? Who? A motion to dismiss under KSA subsection 60-212C challenges subject matter jurisdiction. Courts lack jurisdiction to adjudicate matters where the underlying governmental action exceeds statutory authority. This is coming out of State Ex Rel Morrison versus Sebelius, 2008. The Fourth Amendment to the Constitution for the United States of America protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. An arrest without lawful authority constitutes an unreasonable seizure. Peyton versus New York. The 14th Amendment guarantees that no state shall deprive any person of life, liberty, or property without due process of law. An arrest made in violation of state statutory law violates substantive due process. That's County of Sacramento versus Lewis. The Supreme Court in Rodriguez versus United States established that, quote, this one's good. I like this one, y'all. A police stop exceeding the time needed to handle the matter for which the stop was made violates the Constitution's shield against unreasonable seizures, unquote. An arrest for non-arrestable offenses exceeds any permissible scope of a traffic stop. Let's read this one more time because it is majorly important. An arrest for non-arrestable offenses exceeds any permissible scope of a traffic stop. As recognized, now wait, pause here because we're talking about Rodriguez, right? Is that exceeding the time? Yeah, this is. So I want to show y'all something. So I don't know if y'all know the civil rights attorney. I follow my boy. He does good. He does good work. I really like him. I would love to speak with him someday for all the work we're doing here with Operation Wise Dome. But this is his case, and he is defending someone or representing someone in a federal case. And they had a order that came from the judge on March the 25th of this year. And I picked this up as soon as I found it. And it's a memorandum and opinion and order. And again, it comes directly from the judge. Okay, so no BS. This is a really a district judge's entry here. It was e-filed. You can go check out the case if you want to. Okay. And I highlighted a few things in here that were important. Okay, and let's check this out. Now, let's say we've brought forth a federal suit, and the judge is giving a response based on we filed something, and the defendants filed something back, and then now the judge is giving in their order and opinion on the matter. Okay. The plaintiff, me and you, would contend that the deputies stated they initiated the stop because the plaintiff had on his private plates. There does not appear to be a law in West Virginia that criminalizes such behavior. Okay. And we really don't even call them plates. We call them notice placards because we are giving notice to the public that we are privately operating on the roads that are open as a matter of right for public vehicular travel. So they take it as you must. Taking the facts as the court must in the light most favorable to the plaintiff, the deputies allegedly initiated the stop without reasonable suspicion of a crime or traffic violation. Why? Because traffic is transportation, and transportation is transportation and profit on the roads by transporting goods, people, property, that type of thing, right? And then there's a secondary element to that is there must be a posed safety risk, meaning that someone on the road must, if me traveling on the roads and the way that I'm moving about on the roads is some way posed a safety risk to another person of the public, then that would definitely most fall in line to traffic violation, reasonable suspicion. Such a stop would violate the Fourth Amendment. Okay. Now, if we come down just a little bit more, what we'll see is unconstitutionally extending a stop by even a de minimis amount of time violates the Fourth Amendment. And let's dive into that just a little bit and get those likes up, y'all. We got 30 likes. We got 50 of y'all in here. Come on, y'all get them likes up, please. It helps everything. Extending the stop by even a de minimis amount of time violates the Fourth Amendment. What does that mean? By failing to hand over citations and prolonging the encounter, deputies, troopers, city police arguably make the stop longer than necessary to effectuate the purpose of the stop in and of itself. So what I need y'all to really understand here is this is a federal case. Okay? This is a federal case. That means that any traffic stops that are extended even by a de minimis amount of time violates the Fourth Amendment. If you've found me for speeding, write the ticket for speeding. If I got no insurance, write the ticket for no insurance and let me go. If I have no driver's license, write the ticket for no driver's license and let me go. This isn't I get to now investigate, pull you out the car, tow your car with this whole licensing scheme that has happened. Because, again, unconstitutionally extending a stop by even a de minimis amount of time violates the Fourth Amendment. By failing to hand over written citations and prolonging the encounter, all of these cops are making the stop longer than necessary to effectuate their purpose. Uh-oh. Now, while it is true that an officer may order a suspect, not just a random person that you've stopped for a traffic infraction, she is Thomas is, and this judge is very specific. A suspect. Why is it a suspect? Because there must be a suspect involved. There must be probable cause for a suspect who is involved in a potential crime. That's how this works. I need to charge my. Is this hooked up? Okay. Hopefully it's charging. Okay. Let me check it. Plugged in. Okay, we're plugged in. Okay. Now, they may order a suspect out of the car during a voluntary stop. Okay. Suspect. Lord Primate, welcome to the Traffic Law Reform Support, brother. I really appreciate y'all. Everybody throwing one in the chat. Say thank you to Lord Primate for joining Traffic Law Reform. If you don't know about Traffic Law Reform, I have to shout it out now. If you don't know about the Traffic Law Reform, what we are doing is we have begun a petition, and we have already created legislature, or started to create. It's not completely done yet, but we've created a petition to get signatures to change petition for immediate traffic law reform to uphold the constitutional right to travel. And this is across the United States, y'all. Okay, across the United States. We're proposing solutions such as the decriminalization of minor administrative violations, strengthening the right to travel, comprehensive overhaul of traffic enforcement, limiting police authority in traffic stops, and then persuasive augmentation as well, right? For all the criminalization that's been happening to us. Now, what I wanted to show you is it's not just about a petition. We've actually, let's see, Washington. What we've already done is for 2 states, we've already created a bill that we seek to introduce and get sponsors and support through different representatives. The first 2 that we're going to be aiming for right now is directly through Washington State, as well as Illinois. And again, what we've done is we are now legislative authors as well. And this is an act relating to the recognition and protection of the unalienable right to travel, reclassification of commercial motor vehicles, and the exemption of non-commercial conveyances from registration and operators' driver's licensing requirements. Okay. This is a bill that would affirm and codify the inherent and unalienable right to travel as recognized by the Washington State Constitution and federal jurisprudence, and requires the Department of Licensing to provide at no cost to all non-commercial automobile and non-commercial conveyance owners a decal and identification card that state the holder is exempt from registering his or her automobile and other private conveyances under the superior authority of RCW 62A 9A-109 of the Uniform Commercial Code, which provides exemption for non-taxable consumer goods and household goods. This bill further distinguishes between commercial drivers and non-commercial travelers, repealing requirements for certain travelers to acquire non-commercial driver's licenses, thereby restoring the constitutional distinction between regulated commercial activity and protected private conduct. Okay, so yeah, we out here really writing legislative laws and bills to get introduced and change everything. So again, I just wanted to give a shout out to Lord Primate. Thanks for being a member, man, and supporting us in the traffic law reform. That really means a lot. I really appreciate it. Okay. Now, the Supreme Court in Rodriguez versus United States established that a police stop, extending the time needed to handle the matter for which the stop was made, violates the Constitution's shield against unreasonable searches. An arrest for a non-arrestable offense exceeds any permissible scope of a traffic stop. The charges must be dismissed because Kansas law explicitly prohibits arrests for traffic infractions. The foundation of this notice and demand rests upon the bedrock principle of statutory construction and the rule of law itself. When the Kansas legislature speaks with clarity and precision, courts must give effect to the plain meaning of the statutory language, State versus Arnett. Here, the legislature has spoken with unmistakable clarity. People cannot be arrested for traffic infractions. Oh, by golly gee, does it really say that, Cameron? Yes, it does. You can't arrest them. You can't arrest them, buddy. You can't arrest a person in Kansas for traffic infractions. That's what it says. It says it right here. KSA subsection 22-2401D provides the exclusive authority for warrantless arrest based on crimes committed in the officer's view. The statute states, quote, any crime except a traffic infraction. Except a traffic infraction. Except a traffic infraction. Let's just look it up. I'm not even going to do this with y'all. They're going to call me a liar. They're going to call me a liar. Any crime except traffic infraction. You cannot get arrested for a traffic infraction. My boy got arrested in 2 weeks for the same thing, bro. Then they just be coming up and saying, oh, you failed to identify. Bro, you didn't even give me 23 seconds before you illegally asked me to step out of the car. Like, what is you talking about? You mad because I'm not doing what you say? It's a retaliatory action. Retaliation in and of itself is a big lawsuit. We're talking federal, not just state tort. Has been. This language is not ambiguous. It's not conditional or subject to interpretation. It is what it is. It is an absolute prohibition. You prohibited. You prohibited. Prohibited. The word except creates a categorical exclusion. Traffic infractions are specifically and intentionally removed from the universe of offenses for which warrantless arrests may be made. The exclusion reflects the legislature's recognition that traffic infractions are fundamentally different from criminal offenses. They are civil violations that do not warrant the deprivation of liberty that accompanies arrest. You see how screwed you are, Butler County, for doing what you did? Do you understand the illegal, egregious actions, Butler County Sheriff's Office? Not once, but twice. Then you're over here recognizing it and taking the aspect that, no, the captain, no, I take responsibility. Those are my guys. I ain't even put that up yet. Ain't nobody even seen it yet. I had to fly my ass all the way out to Kansas to go tell these people that what they were doing was wrong, and they better stop it. We had to go over there to the court, go to the sheriff's office, file notice of liabilities. Now we got to file a class action lawsuit separate from the civil lawsuit. Because apparently you people are ignorant of the law. Not to be disrespectful. Apparently you're just ignorant. But again, it doesn't matter if you're ignorant or if it's by design. You're still going to, you must respond in damages. Roger versus Marshall. Not shall, not can, not hopefully will be, must. We don't need anybody to tell us, as far as an attorney is concerned, where there are damages. We're just going to bring it forth because we know. Don't mess with my life, liberty, or the pursuit of happiness. I'm a creation of the Creator. Don't you ever think you are going to mess with my life, liberty, and the pursuit of happiness and not be held responsible for it. I am a creation of the Creator. You don't tell me what to do. That's how this works. That is how this works. God is great in that. It's not about being mean. I don't wish to be mean. I don't wish to be belligerent. It's about knowing your place in this realm. I am. The statutory language is clear and unambiguous. When statutory language is clear and unambiguous, courts must give effect to the plain meaning without resort to rules of construction. State versus Gracie. The phrase, except a traffic infraction, unquote, admits of no exceptions, qualifications, or judicial modifications. It means exactly what it says. Traffic infractions are excluded from the arrest authority granted by the statute. The Kansas Court of Appeals in State versus Cockrell. This is another great case to utilize as well, y'all. analyzed the requirements of KSA subsection 22-2401 and emphasized that warrantless arrest must comply with statutory requirements. Okay. It's already been decided. In 2016, it was already decided 9 years ago. But yet Butler County still thinks it can do whatever the hell it wants. Guess what, Butler County Sheriff? You got something coming to you, buddy. The court stated that, quote, the crux of this appeal is whether the warrantless arrest of Cockrell complied with the provisions of KSA 22-2401C2, and that the state has the burden to prove that a warrantless search and seizure was lawful. Well, let's look at what a warrantless search would be. This isn't warrantless search. So let's look at what warrantless arrest would be. Oh my gosh, it's not charging. I thought I got you plugged in, dude. Come on. No? Okay, hold on. Give me 1 sec. Get the charger. Well, how do you make this work, Cameron? Y'all better quit making fun of me. I sound funny. Look, talking to myself. Chill, bro. Can y'all hear me now? Everything good? 5 by 5. What's up? Talk to me. All right, cool. So get back to sharing entire screen. All right. So this is, of course, Kansas statutes, chapter 22, criminal procedure, article 27. And this is again 22-2714, arrest without a warrant. This is in Kansas. But if you go and look up what I just did, look what I just did. All I got to do, look, all I just did was Kansas warrantless arrest. You can do the same thing for your state. Now, we use what's called the rule of lenity. The rule of lenity is a doctrine in which you can invoke that makes it to where the state cannot go outside of the statute in and of itself. So this statute right here is pretty clear that if they go outside of it, it's not going to hold up. Okay. The arrest of a person may be lawfully made also by any peace officer or private person without a warrant upon reasonable information that the accused stands charged in the courts of a state with a crime punishable by death or imprisonment for a term exceeding 1 year. Well, that right there is pretty cold cut case clear that Quentin or anybody in Kansas that's getting arrested for a traffic violation is not to be arrested. You're only supposed to be arrested if there's a warrant, or you're in the commission of a crime, or you've committed a crime that is for imprisonment that exceeds 1 year. And I don't think anybody can get imprisoned for more than 1 year for like a traffic violation. Now, of course, DUIs and stuff may be different. I don't really think pre-crime is a thing. To me, I'm not about punishing people if they haven't harmed anybody. So until harm is made, I don't think you should be punished. Like, it's a free world. People can do as they please. Me personally, as long as you don't hurt somebody. If you hurt somebody, hey, it's a different story. So again, hence the state cannot meet its burden because the warrant was made for traffic infractions. Hence, the state cannot meet its burden because the arrest was made for traffic infractions, which are explicitly excluded from warrantless arrest authority. The officers act without statutory authorization, rendering the arrest unlawful ab initio from the beginning. Yeah, I got to smoke some weed now. Y'all got me all out of my zone. This whole shebang. What? Y'all toke up. It's Saturday. You're chilling with your boy Cameron Wilson. This is Power Inherent in the People, and we get into that knowledge, you dig? Knowledge and wisdom. The knowledge is of yourself, but the wisdom comes from God. If you ask God for wisdom, and that be the thing you cherish the most, watch how your life flourish. I'm telling you right now, because it's going to reflect in everything that you do. The more wisdom that you gain, the more respect you're going to give, the more unity you're going to create within everybody that you operate with throughout this realm. All that little shit ceases and all the big shit starts to manifest more and more and more, and things just flow in abundance towards you, because that's what the universe wants. The universe wants you to succeed in a positive manner and become the greatest potentiality self of yourself, because it is you. You out here wasting the life that you got by not manifesting and being the best that you can be. That's crazy. Check. Okay. All right, let's get back to it. Traffic infractions are civil violations, not criminal offenses. The distinction between traffic infractions and criminal offenses is fundamental to Kansas law and reflects a deliberate legislative choice to treat traffic infractions as civil matters. KSA subsection 8-2118 defines traffic infractions as civil violations subject to civil penalties, not criminal sanctions. This distinction is not merely semantic. It reflects the fundamental principle that the power to arrest and deprive individuals of liberty should be reserved for conduct that truly threatens public safety or violates the criminal law. Criminal law. Traffic infractions, being regulatory in nature, do not rise to this level and therefore do not justify the extraordinary governmental power of arrest. The United States Supreme Court in Buck versus Kendall, 1925, recognized the fundamental distinction between the creator endowed right to travel and commercial regulation, stating a citizen may have, under the 14th Amendment, the right to travel and transport his property upon them by auto vehicle, but he has no right to make the highways his place of business by using them as a common carrier for hire, unquote. Ding, 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 ding. This principle establishes that private travel is a fundamental right, while commercial use of the highways is subject to regulation. Traffic infractions related to private travel implicate this fundamental right and therefore require heightened protection. Heightened protection against governmental overreach. It's heightened. Legislative intent and clear must be respected. The Kansas legislature's intent in excluding traffic infractions from arrest authority is clear and unambiguous. By creating this categorical exclusion, the legislature recognized that 1, traffic infractions are fundamentally different from criminal offenses. 2, the civil penalty structure is adequate to address traffic violations. 3, arrest is an inappropriate and excessive response to regulatory violations. And 4, individual liberty must be protected from governmental overreach in traffic enforcement. Courts have no authority to rewrite statutes. Courts have no authority to rewrite statutes. Courts have no authority to rewrite statutes or ignore clear legislative mandates. Yeesh. That one hurt. That one hurts. State versus Thompson. The legislature has spoken and its word is the law. Yeah, nigga, what's up? Like, we know the law. You're not just gonna run over me like that. Officers who arrest individuals for traffic infractions act without lawful authority and exceed the powers granted to them by the people through their elected representatives. You gonna listen? The Fourth Amendment protects the creator endowed right to be secure in one's persons against unreasonable searches. An arrest made without lawful authority is per se unreasonable and violates this fundamental constitutional guarantee. Now, do you see how many constitutional violations are on the forefront? So if there are this many constitutional violations on the forefront, how are we even going to be talking about a violation? You weren't even supposed to arrest me, homeboy. You weren't even supposed to arrest me. The Supreme Court in Rodriguez versus United States established that a police stop exceeding the time needed to handle the matter for which the stop was made violates the Constitution's shield against unreasonable seizures. The court further held that authority for the seizure ends when tasks tied to the traffic infraction are or reasonably should be completed. You're supposed to get my name, go write up what you needed to write up, and then come back with that. You're not supposed to get out of the vehicle. And then when I ask you, hey, man, well, I ain't got my ID with me. I live at my girl's house. We just running this car back. That's why she followed me. That's why she pulled up right here. That's why she was behind me, so we wouldn't have to worry about getting pulled over. We was just taking the car back to the house. You know what I'm saying? We just picked it up. You know what I'm saying? But here you come rolling around her real crazy. So, I'm going to verbally ID. Can I verbally ID too? That's cool with you? No. What you mean no? Now you about to arrest my ass? Well, what are you arresting me for, bro? What crime have I committed? You took too long. What? What you talking about? You got private plates on. What? What you talking about, bro? Get out the car now before I break it. What? Where they do this at, bro? This is not slavery. We live in America, bro. Please stop being bad cops, bro. Butler County Sheriff's Office, please stop being bad cops. Y'all better than that, man. The captain had to come out and speak for y'all. We had to all come up there. All you deputies out there in Butler County. And you judges, because I'm watching you judges out there calling people sovereign citizens on the record when they are literally, they have no jurisdiction truly. The court, you have no jurisdiction truly. The prosecution has no jurisdiction. The state can't get no jurisdiction whatsoever. The damn captain doesn't admit that everything they did was completely wrong. And you're over here just willy-nilly thinking you can do whatever you want. We're just gonna call these people sovereign citizens and we're just gonna willy-nilly go crazy. Y'all better than that, man. Please do better than that. Start respecting people's rights for the constitutional violations of a few bad apples that y'all need to get rid of. Get rid of them bad apples. You won't have people calling you out. I'm not saying every person's bad in your county. You did have a couple rude ones at the court clerk's office. They didn't want to talk and smile and they were short. But beyond that, I mean, we all better than that. For real, man. Y'all gotta be better. I don't know what's wrong with just being a good person. So the court further held that the authority for the seizure ends when the tasks tied to the traffic infraction are or reasonably should be completed. That means you pulled me over for this reason, issue the citation, and let me go. This is Rodriguez versus United States. It's like nobody's mentioning these big ones. They're not supposed to be arresting you, bro. Don't you get it? You're not supposed to get arrested. A de minimis amount, extending it, a de minimis amount. Further, is a violation of my Fourth Amendment, your Fourth Amendment rights. Stop allowing it. Under the Rodriguez analysis, the officer's authority was limited to addressing the traffic infractions through the issuance of citations. The decision to arrest exceeded this authority and violated the Fourth Amendment. Since Kansas law prohibits arrest for traffic infractions, any arrest necessarily exceeds the permissible scope of a traffic stop. As emphasized, the use of force was objectively unreasonable. The officer's use of force in threatening to break Mr. Hite's window and forcibly removing him from his vehicle was objectively unreasonable under the standard established in Graham versus Connor. The Graham factors, severity of the crime, immediate threat to officer safety, and active resistance all weigh against the use of force here. Oh, bet you wasn't paying attention to that one, was you, Buster? You didn't want to talk about or mention those elements that must be met in relation to the Graham factors. Why ain't nobody talking about the Graham factors? Graham versus Connor. The Graham factors. Graham versus Connor. The Graham factors. You need to start using the Graham factors, okay? Because what do they include and what are they? The severity of the crime, immediate threat to officer safety, and active resistance. Me merely questioning an unlawful act when I know of such, while reserving said rights and waiving none, does not mean I am actively resisting you. It only means that I'm flexing on my unalienable rights that a creator endowed, nature derived. So who are you or anybody else to tell me otherwise when you have no reasonable suspicion of a crime? Who are you? That badge doesn't magically make you into somebody above me until there's harm. So the Graham factors are the severity of the crime, the immediate threat to officer safety, and active resistance. They all weigh against the use of force here or in most situations. Okay? Again, officer safety. Do they see a gun? Do they feel harmed? Do they feel threatened in any manner? If they don't, they can't ask you to get out. That's how this goes. Traffic infractions are minor civil violations, not crimes. We all pose no immediate threat to officer safety. We are normally not actively resisting or attempting to flee. And under those circumstances, the use of force will be and always will be constitutionally excessive and in violation of our Fourth Amendment rights. See, because the 14th Amendment's due process clause protects individuals from arbitrary governmental action that shocks the conscience. Ooh, have you heard that one, guys? Have you heard about what shocks the conscience? I'm talking about Jesus. Get hit with the Holy Ghost. Talking about shaking your soul, my heavenly dear. In legal terms, shocks the conscience refers to actions or decisions that are considered grossly unjust. Yes, they are. Outrageous. Yes, they are. And are fundamentally unfair to the observer. Yes, they are. And you want to know why I be telling people they need to get more petty, bro? Because I'm going to tell you like this. And I don't know if I told everybody, so I'm going to tell y'all like this. When I went out, bro, to Kansas to see my friends, they're a different breed, right? And I've been calloused so much, bro, with actions and things that have been done against me, like people that have done me bad. And I've become so calloused from that, like worn out, that I don't even recognize how bad what has happened to me is. And I know some of you are like that. You've had a little bit rougher life. You've been beat up from these people, and you just know, ape, that's how it goes. But other people has never had this happen. So it's like, for them, it's like they're making me realize again how serious these things are and how much I really need to comprehend and know within myself of how petty I need to be. And I'm not meaning petty as in like, oh, Karen Kin type vibe. I'm talking petty as in like, yo, you did this and you did that. Oh, yep, it'll do it, but it keeps trying to show my camera. So, but when so arrested, where's we at? Oh, yeah, this is a whole nother screen. Shocks the conscious. That's where we. But it made me realize just how petty I need to be, because what I'm realizing all over again is that every single thing that is happening to me is egregious, and it's not okay. It's not called for. I should see due process. I should be respected in every single way possible. Like, it's not fair that these things are constantly happening to. What? Why is it saying I don't have